Getting ready for your mediation, what you need to know. Nervous? Relax and watch this video in its entirety. You will have the answer to all of your questions.
Hello, this is Muhammad Alam, your lawyer. Today, I am going to speak to you and give you some heads up for your upcoming mediation. I know you must be aware that your mediation is coming up and you may have some sort of anxiety as to what is going to happen at mediation. And the purpose of this video to provide you some information and give you some information so at least you are ready and you are not overly nervous about this process. Mediation is an informal process, and it should be taken as a settlement meeting, but in a formal word, it's called mediation. And mediation, most of the time, a mediator, the lawyers and parties, they use their first name. The purpose of the mediation is really to explore the opportunity if your case is now ready to settle. Obviously, it depends on many factors whether or not your case is ready to settle and will be settled at mediation on many factors. Number one, whether or not the other party is ready, whether or not they have enough money to compensate you for your losses, whether or not they just don't see your case to settle and they want to take your case to trial. Now, this is a very important process, as I said, in Toronto, Ottawa, and Windsor. If your case has started in these three jurisdictions, mediation is mandatory before you move to another process. But all other jurisdiction is not mandatory, but our office always requests mediation because we believe a case should be discussed, and we have to explore all the reasonable opportunity to see if this can be settled. Now, mediation is as I said, like a very informal process. Everybody use first name. There will be a mediator who was selected by both parties, means your lawyer and the insurance company's lawyer. Mediator is neutral. Mediator generally are experienced lawyer in the area of law that they are mediating. In the mediation, you should also not be nervous about attending this process, as nobody is going to ask you any question, unlike your examination for discovery. At mediation, all you need to listen. You don't have to agree. So let's take an example. At the start of mediation, which is called openings or opening statements, where I will start talking about your case. I will explain to the other party and their lawyer as to what injuries you have suffered, how these injuries have affected your life, how these injuries have affected your activities of normal living, how these injuries have affected your working capacity and work, and so on and so forth. Now, the other party, even if they disagree, they have to listen, because it's important for them to listen so they understand how I'm going to present your case in front of a judge and jury. Similarly, the insurance company's lawyer, which is defense lawyer, they will be, after I finish my opening, they will start their opening statement. And I bet you in majority of the cases, plaintiff or a client like you will not agree to majority of their opening statement, but that is okay. This is what the process is. So even if you disagree for everything what they have said, that is absolutely fine. You don't have to interrupt them You don't have to be angry by listening their argument. If they are wrong in certain factual things, you can write on a piece of paper and then you can discuss with me when the mediator will break both parties apart into separate room. But not about the opinion. As I tell you now that you will not agree with whatever they will say. But if they are wrong in factual, so let's take an example. If you are 31 years young person, and if they're saying plaintiff is 41 years young, that's factually wrong, and that you can correct them through me. Now, the process itself, as I said, that in this process, you have to be patient. You have to show them that you are listening. You have to look at them in their eyes if you're sitting in a boardroom. Many mediation these days are being conducted virtually through Zoom or other platforms. So even if you are attending through virtual means, you have to make sure a few things. Number one, that the place that you are attending, it's an isolated place. It's not a public place. It's a place where only you are, alone. So there is no distraction. Even if you are at your own home, it should be a separate room. Nobody else should be sitting there. And if another person is sitting in that room, you have to disclose that. You're not allowed to record any of the proceeding because this is a confidential process. Before the mediation starts, mediator will ask that if all parties have confirmed the agreement, and that agreement essentially talks about the confidentiality process and provisions, which essentially means each party will have to sign this agreement, and this means that we are bound by the terms of this agreement. And one of these terms is that you will not disclose the information or offers that was exchanged during this mediation, which essentially means that if parties are, if the insurance company has offered you X amount of dollar, and at the end of the day, we were unable to settle this case as the offer was too low. If the case goes to trial, you cannot disclose, number one, the offer that the defendant was willing to put X amount of dollar in 2022 at a mediation. Similarly, if the other lawyer has accepted certain aspects of your case, either about some of your injuries or some of the liability portion as to who is at fault, and they may accept that their client is at fault at the mediation, but if they have not accepted formally and this case is not settled, when the case goes to trial, you cannot point out any of those information. So essentially it's a confidential process, whatever happened at mediation. So it's a kind of a Vegas rule. Whatever happened at Vegas stays at Vegas. Now, moving forward from there, after the opening statement, the mediator will put us into a private or a breakout room. And similarly, mediator will put the insurance company's adjuster and insurance company lawyers in separate room. Insurance companies adjusters, now who are they? They are in fact the decision maker on the other side of the table. Like you are the decision maker in your case. Your lawyer, as me or one of our lawyer who is representing you at the mediation, we don't make decision. We give you advice based on our experience. Similarly, on the other room, the lawyer give advice to insurance adjuster, and it will be at the disposal of insurance adjuster whether or not he or she listen to his or her lawyer's advice in terms of settling this file, offering more money than the lawyer has recommended. It's so there are two decision maker. One is you, and one is the insurance adjuster. Now the mediator will come to our room Make sure that you don't volunteer information to the mediator without first you consulting me. In our breakout room, you're free to share any information with me. Mediator will come and go from our room. So he will, like a pigeon carrier, he will come to our room, speak to us. If there's a message from the other room, he will convey that message. He will take our offer and take that offer to the other room. Mediator also gives some sort of opinion based on their experience, based on the value of the case, based on some merits, some issues in your case. But not necessarily we have to listen what mediator is saying. It's an important day. Most of the cases, as I said, 75% cases settled at mediation, but not all. But 75% cases really means a lot of cases settled. 7.5 cases settle out of 10 cases, which means this is a real opportunity for us and for you to seize this opportunity and settle this file at your mediation. Mediation, when offer will be exchanged, most importantly, that each side will have to sacrifice and compromise from their best position in court. So let's take an example. If I believe your case is worth $10, not necessarily that at mediation the defendant will offer $10, but that's the beauty of the mediation, that without compromising the real value of your case, if you want to settle your case early, if you're getting less money than what I believe you should be getting. So take, for example, $10. If that's the real number that I believe your injuries and you should be compensated for, and at mediation, the other party's last offer is $7. There is always some advantage to take a little less money and settle at mediation, because after failed mediation, your file will now go for a trial, which is obviously a risky adventure. Nobody can anticipate the outcome of a trial, because now the decision will no longer be in your hand. It will be in the hand of a jury or a judge, and they will make a decision, and you or insurance company will have to live with that decision. So as such, as I just will reiterate, this is an important opportunity for litigant, for an injured person like you, to seriously consider offer. And of course, I, being your lawyer, have enough experience to tell you whether or not an offer is reasonable. Should you consider to take that offer or not? In both cases, decision will be yours. Moving forward from this aspect, if case is settled, both parties will sign the paperwork and you leave your lawsuit behind you. But if we don't settle your file for many reasons, one reason could be if the real value of your case is $10 and the defendant, which is insurance company, have only brought $2 to offer, and they will still start with very low offer, and at the end of the day they will reach to $2, which essentially means whatever they have brought to the table to settle this file, they will put that number before they leave. But not necessarily all the cases should settle. If I believe that their offer is very, very low, if I believe that insurance company wants to test you out, if I believe that insurance company wants to test your muscles and your lawyer's muscle, and just making a very low ball offer, I will tell you, I will give you my advice on that. In terms of attending mediation, there are a few things that you have to keep in mind. That you have to be on time, a few minutes earlier. In fact, most of these mediations are being conducted now virtually, which is either Zoom or other platforms. Again, you have to be very careful that you don't make any other commitments during that time. If your mediation is half day, which may end up by 2 p.m., or if it's full day, it may end up by 6 p.m. So please don't make any other commitment during your mediation day, as you can't leave, because if you leave, we will probably lose an opportunity to settle your file. Now, the second thing, that you should dress appropriately. I'm not suggesting that you should be wearing suit, but just a regular cloth that you wear on an everyday basis. For our women's client, just avoid using makeups and stuff. Just be as you will be at home on an everyday basis, because I want the insurance company to see you as a real person, as an ordinary person who is living on day to day, how you're living. There are times people make mistake because of virtual appearance through camera. Sometime client make mistake and they are dressed up, overly dressed up, makeups and stuff. So I suggest that you should avoid doing that, because I like you to be present yourself, so in a manner that you live every day, with your pain, with your injuries, with the agony that you have been living for several years as a result of the accident. You also have to make sure confidentiality, which is extremely important. Mediation is a confidential process, which essentially means whatever is discussed at mediation cannot be disclosed at trial. So let's take an example. If you attended a mediation and there was an offer made by an insurance company, let's say $10, and case did not settle because you believe and I believe that your case is worth a lot more than that, you cannot, if your case moved to trial, you cannot disclose or you cannot state at trial that the insurance company had offered you last year $10, why they're not offering today. Similarly, if insurance company's lawyer have admitted certain thing, so let's take an example. If they says, yeah, we believe that our client is at fault of the accident during mediation, or if other lawyer or insurance lawyer has accepted that we understand that you have ongoing back pain, and case did not settle, you go for trial. At trial, if the other lawyer is questioning about your back pain or is taking a position that his or her client is not at fault, you cannot intervene and say, hey, you are wrong because you accepted last year at a mediation that your client was at fault. So it's a confidential process. Parties have to sign the agreement before we attend. If the attendance is in person, you will be signing a mediation agreement in the room in person. And if it's virtual, then there are times that I can send you the mediation agreement to sign, or at the other time I sign on behalf of you, or I confirm to the mediator that myself and my client agrees to the terms of the mediation. So that's the confidentiality side of the case. As I suggest, that you have to be patient, and this is really an opportunity to settle your file. Sometime at mediation, even if I believe your case is worth $10, I recommend sometime taking less or little less than $10, even $7.50, because that will give a closure to your case. That will give a certainty, that will give you a confidence that this money will be in your hand. Because if you don't settle and you're not willing to compromise, and you want to go for trial, then decision will no longer be yours. The decision will be in the hand of a judge or a jury. Whatever decision they will make for you, you will have to live with it. So if the jury come back with an offer of a judgment way less than what the defendant has offered you, you will have to live with it. In addition, there are always some sort of cost consequences, which means if a defendant has offered you $10 at a mediation and you did not accept that offer, and as a result, insurance company can put an offer in writing after failed mediation, and you proceed to trial, and at trial, the judge and jury has granted you even $1 less than that offer. In that case, you will be stuck with the legal cost of the other party. So there are a lot to understand about the cost consequences, which obviously I will speak to you, or one of the lawyers who is attending your mediation can talk to you, can give you our suggestions and recommendation, at which stage we should take a case to trial, which cases are not good for trial, which cases we should take less money and settle, what are the risks. All these things will be discussed when the offer will be exchanged between parties. And also remember that I, being your lawyer or another lawyer from my office who will be attending, we put a very high offer. And that high offer really just to test the water. It really does not mean that I am serious and believe that insurance company will give you that money, or believe that even your case is worth that much. It is just a way to test them, because when their counteroffer will come, and that we know that their counteroffer will be very, very low. So the plaintiff lawyer, your lawyer, will start from ceiling, and the defense will start from the floor. But that's not, the first offer is never, you should judge that whether or not insurance company has more money in their pocket. It's the last offer that is important, when you have to seriously consider, because after that last offer, if they leave and mediation is failed, you have to then be ready to take your case to trial. I have seen over the years, some of our clients get attached to my first number. So even if I believe your case is worth $10 and I should be settling for $10, I put $30 or $25 as a first offer, just to see the progress, see where the other party or insurance company is at. And then I have to drop the number, because if I don't go too close to my final number, then case will not settle. So you will have to trust your lawyer that we know the negotiation a lot more than you, the strategy, how to drop your offer, what does it mean? Each offer, each time when insurance company will give a counter offer, those counter offer carries a message, and we can see that message. We can tell you what does that mean. We can explain to you that their fourth offer really means that they have X amount of dollar in their pocket. Remember this, it's a process, and I generally give a very simple example, that at mediation, when negotiation starts, you should imagine that I have a lemon in my hand, half cut, and there's a glass, and I try to squeeze the lemon, which essentially means I'm squeezing insurance company to pay more money. And I keep squeezing and squeezing and squeezing, which essentially means the money will, their offer will increase and increase. But there will be a time when there will be no more drop of lemon will be left. And if I squeeze any more, the skin of the lemon will break, which essentially means the mediation will fail. So at one point, I will tell you that there's no more money on the table. Whatever they have brought to settle the file today, that is the money on the table. You and I can discuss whether or not, is this case should be settled today. Both mediator and the insurance company's lawyer, they both will have, in advance of mediation, a disbursement list, which essentially means the money that I have incurred to advance your case, to fund your lawsuit. That's called disbursements. So the insurance company already know before coming to mediation that X amount of dollar was incurred. Any offer that they are making, whatever offer we will be making an offer, $10, and then I'll say plus, which essentially means that I'm saying not only $10, but insurance company should also pay cost and disbursement. And then insurance company can come back also with the plus offer, which means that they are willing to pay $2 and your lawyer's cost and disbursement. But at one point they can put an all-inclusive offer, which essentially means that if your case is worth $10 and your disbursements are $2, this essentially means $12 all-inclusive offer. If insurance companies offer you $9 all-inclusive, which essentially means that they are willing to pay $7 for your claim and $2 for the expenses, that's disbursement. That disbursement does not goes to you. That disbursement is being paid, considered and paid by insurance company. That is the money that I and my office has we have incurred on your behalf, and that money will obviously be reimbursed towards the disbursement, and the damages award that was agreed will run the calculation with you, which essentially means how much will be my fees, how much will be the taxes, and what net amount you will get in your pocket before you make a final decision. So thanks a lot of information today. You do not need I believe any more information before you attend the mediation, but if you would have any other question, you can just write down those questions and you can ask me during mediation or just prior to your attending the mediation. And the last thing, make sure that you attend the mediation on time. Make sure that when you at the place, if you're attending from my office, then you will have a dedicated room. But if you're attending it from your home, make sure that you have an isolated room, which means like a lot of people should be in your background or coming in and out, because that will distract everyone. And also, if the mediation is going through virtual means, which essentially means that you have to ensure that the process is not being recorded, because this is also part of your mediation agreement. And if there's anybody else sitting in that room and listening the conversation, you have to disclose to me, so I can disclose to mediator and other party. By all means, if you really want your spouse to be attending with you, but that person should be in front of camera, you have to disclose the person identity. That person will also have to sign a confidentiality agreement for attending this mediation. So with that, I will just end up this video at this point. Write down any other question that comes to your mind, and we can discuss at your mediation. See you then. Thank you.